We are back with another edition of what, Tiffany?
Cover your assets.
Yes.
In real estate.
That's right. Cover your assets. And this topic right now is the RPOADS, Residential Property Owners Association Disclosure Statement. Say that 5 times fast.
RPOADS, 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 RPOADS.
She's cheating. She's cheating. But that's just an example of what we're going to be doing here today. Yes. Tiffany and I are about to duke it out, okay?
Okay.
Not really, but for real. Okay. We're going to be discussing the RPOADS. And matter of fact, Tiffany had a scenario.
Okay.
Not too long ago. Tell us about it.
So here's the scenario, and this is what we need to duke it out. You all need to be very careful that you understand and that you advise your clients correctly concerning filling out the RPOADS.
Okay.
This is the form that we cannot, as agents, do what?
That's right.
We can't fill it out.
We can't fill it out for them.
And so, with that in mind, you have to have a good understanding and make sure you educate your client.
And be able to explain it to your clients as well.
So, the scenario is this.
Okay.
You have buyers that are putting up a lot of money now.
Yes.
Talking about $20,000+
in the 5 digits
of due diligence. And in the past, maybe it hasn't been such an issue.
Right.
But now they are relying even more heavily on that seller's representation on the RPOADS. Okay?
Okay.
And so there are 3 options. What are the 3 options, Teresa?
The 3 options are, no, I'm only kidding. The 3 options are yes, no, and no representation. What does that mean? What is no representation?
That's a good question.
Okay.
And I think that's where a lot of people are confused.
All right. Let's talk about it.
North Carolina is a caveat emptor state, which means what?
Buyer beware.
Buyer beware.
Buyer beware.
Which means the seller does not have to represent anything on that form.
Anything at all.
They can choose no representation the whole way down.
Yep.
And they don't have to represent a thing.
Exactly.
Okay.
All right.
Now we understand that.
We do understand that.
With that in mind, the seller is advised to answer truthfully what they know about that property.
Okay.
And so the yes and the no, they have those options.
They do.
When they are answering it, they have to, what they're saying is they know their property and they know for a fact that there is or is not an issue with that particular question. All
right. So let's talk about what you ran into.
Okay. So we ran into a buyer who relied on a seller's representation of no all the way down, that there were no issues in the property.
Okay.
So this buyer felt comfortable with a very large due diligence payment.
Okay.
And they went forth into the contract.
Okay. 5 digits, right?
They were over $20,000.
Oh,
We're talking big due diligence.
Okay.
Okay. So the buyer continued to investigate the property and found several major issues with that property.
Okay.
Major ones.
What did the seller do?
Minor. We're not talking about, like adjusting the hinges on the doors. Okay. We're talking about major issues.
Okay.
And so when the buyer addressed the seller about those major issues, the seller did not want to make any repairs.
Okay.
Okay.
All right.
All right. So then the buyer, now we have a little bit of problem here.
Okay.
Because the buyer has a lot of money on the table.
Okay.
And the seller's not willing to make repairs, and they don't have to.
They don't have to.
They don't have to.
Okay.
So this buyer is then, well, what options do I have when I have so much money?
All right. At stake here.
Yes.
They put lots of money on the table. What did the buyer do?
The buyer spoke to an attorney.
Okay.
Okay. And
Which we are to advise our clients to do when it comes to those types of matters.
Because you are not attorneys.
That's right.
Unless you are. Right. Okay. And so make sure that if it comes to a legal question, make sure that you refer your client to an attorney.
Okay.
So this wise agent did so. The buyer did speak to an attorney.
All right.
And that attorney advised that buyer that because of the way the seller filled out the RPOADS, that they actually had a right to get their due diligence money back.
Really? What happened to caveat emptor? Buyer beware.
Yes.
What happened to that?
Well, the buyer beware, the caveat emptor was not in place in this case because the seller made a actual representation.
The seller said no. All right, Tiffany, so the seller said no. Okay. Now, you got to tell me, how did this play out?
Okay, excellent question.
Okay.
So the seller in this case
Okay.
decided, instead of going through a lawsuit, that they wanted to go ahead and address it. And so the seller did release not only the due diligence funds, but also all of the buyer's expenses in all of the investigation of the property.
Okay.
So the seller released the due diligence back and reimbursed that buyer.
Seller gave back all of the money and the buyer's expenses in conjunction with the transaction. How do you feel about that? I'm still buyer beware, right? Buyer beware. Now I hear the attorney, but you know, I told you Tiffany and I are going to duke it out, so I'm going to do some devil's advocate here.
Okay.
That attorney, that's his opinion.
That is an attorney's opinion.
He's not a judge, although he is an attorney. I get it. But why not attempt to duke it out in court? As a, you know, buyer beware. Why am I, as a seller, why am I giving this money back? I didn't technically breach the contract, right?
Technically, you didn't breach the contract.
Okay.
But again, it's about understanding what the purpose of that form is and using it correctly.
Okay.
If that seller had selected no representation instead of no all the way down, there wouldn't be an issue.
Okay.
The issue here is that when you select no on that form, what you're saying is that you are completely aware of everything going on in that house on that particular question, and you know that there is no issue or no problem.
Okay, so now I have a problem with the form, right? It should only say no representation.
You know, I have a lot of people say, why doesn't it say, I don't know? Well, if that's the answer, then they should select no representation.
Yeah. Okay. Yeah. Yeah. I have kind of mixed feelings about that. I don't know, as a seller, that I may, as a seller, I probably would have said, you're going to have to sue me.
Okay, and that's fair, and it's up to your buyer and your seller on how they want to pursue that.
Correct. That's not our job to decide what our sellers and our buyers do. It's up to them.
Right? So what is your job? Your job is to make sure that your clients understand how to use that form correctly.
So you mean we have to explain it to them?
You have to explain it to them.
We do?
Both the buyer and the seller clients. What the buyer should be able to depend on in the form, and what the seller's liability is.
Okay.
Right?
All right.
And this is the reason that you cannot fill out that form for them. So that you're not liable.
You know that, right? All right. So in that particular situation, seller said no. There was nothing wrong, which could, I guess, maybe it could have come across as lying, possibly. But if they really, to their knowledge, there was nothing. And which is why it's for the courts to decide.
It's for the court to decide.
It's for the courts to decide.
If the seller earnestly believed that they were answering it truthfully, they may have a leg to stand on in court. But the sheer number of issues that were found in that report, some of them were things that seller had to have known about. And that's where this particular seller decided they must have known for them to decide so easily to refund those funds back.
Okay, and it actually does say that on the form in the instructions to the client when they're filling it out. You know, you could be held liable for not answering truthfully.
Yes, so make sure you read the forms and educate your clients.
How about that? Yeah. All right. Well, that's going to do it for us on this edition of Cover Your Assets in Real Estate. See you on the next one.